This episode of Southeast Iowa Today is brought to you by Griner Auto Body of Washington, Iowa, using state-of-the-art techniques and decades of experience to get your car back on the road after an accident. Car Doctor of Washington, Iowa. No matter who Frankensteined it, they can fix and clean and customize it. McDonald Boneyard of Keota, Iowa, for all of your farm equipment and auto recycling needs. For great food, it's your choice. Your Choice Family Restaurant of Wayland, Iowa. Open Tuesday through Sunday. Try the giant Bain sandwich on your next visit. Girling Repair of Winfield, Iowa. If your mower is dead, call Fred, your Husqvarna, Aaron's, and Gravely dealer. Fred also fixes and sells snowblowers. B&B Propane and the family of Jet Stops. CW Tree Trimming LLC. We're into your trees, not your wallet. Serving all of Henry County and the surrounding area, and we offer a senior citizen and veteran discount. Iowa Technology Systems delivers professional IT services. From company networks to home computers, we keep you connected with reliable service you can trust. Enterprise IT services, quality computers, and local IT support, all designed to keep your technology running smoothly. Visit iowatechsys.com to see how our services can help you. They all present the award-winning Southeast Iowa Today. Get ready for podcast excellence with the author of Christie's Journey, The Beat Goes On, and your host, me, John Bain. It's Wednesday night, February 11th, 2026, and the Iowa Supreme Court held night court in Des Moines, Iowa this evening starting at 7 o'clock. On the docket was number 25-0366, oral argument, Bart Richmond, plaintiff, appellee versus Jefferson County Attorney, defendant, appellant. Bart Richmond is the Jefferson County, Iowa Sheriff, and the Jefferson County Attorney is Chauncey Moulding. Moulding was represented by Assistant Jefferson County, Iowa Attorney Elizabeth Estey. Sheriff Richmond was represented by Attorney Charles Gribble. I will be sharing you video excerpts from tonight's hearing in Des Moines, and I have procured those compliments of the Iowa Supreme Court YouTube channel, and I encourage you to visit their channel to watch the whole proceeding. It was around an hour long, and we will now go to the video and get an explanation from Drew Gensch, Polk County Bar Association President, of appellate court and oral argument about this case where the Jefferson County Attorney was directed by a district judge to remove the wrongfully placed Sheriff Bart Richmond from the Brady Giglio list, and how it ended up in front of a group of justices in the Iowa Supreme Court. And as Chief Justice Susan Christensen referred to it, night court.
Good evening. My name is Drew Gensch, and I am president of the Polk County Bar Association and an attorney here in Des Moines. It is my pleasure to welcome you to this special session of the Iowa Supreme Court. These special sessions offer Iowans an opportunity to observe Supreme Court proceedings firsthand. Later tonight, after the court adjourns, everyone is invited to attend a public reception in the second floor light court. The justices will be at the reception, eager to visit with you, so please feel free to strike up a conversation with them. However, please know that judicial ethics prohibit them from speaking about pending cases, so you cannot discuss the case you will be hearing tonight. The justices can speak in general terms about court procedures, the role of courts, and other topics. This unique opportunity to meet the justices is sponsored by the Polk County Bar Association. Before I explain the work and role of the Supreme Court and the process we are about to observe, I want to thank Judicial Branch Security and Highway Patrol 16 for providing security and the Polk County Bar Association for sponsoring this evening's reception. Now, I will briefly discuss how the Supreme Court works in the process we are about to observe. Most of you have probably seen a trial, either in real life or portrayed in a movie or a TV show. Maybe some of you have even served as jurors. What happens after a trial ends? When a party is unhappy with the result, the party may appeal the case to a higher court called an appellate court. An appeal is a higher court's review of a lower court's decision or a judgment to assure that substantial justice has been achieved. The right of appeal is a fundamental element of procedural fairness in our legal system. The appeal process is very different from a trial. In the trial court, one judge presides over the case and makes decisions. In an appellate court, a group of judges are collectively responsible for making a decision. Why do appellate courts have group decisions? The basic concept of an appeal is that difficult legal questions are decided by a group of judges rather than merely substituting the opinion of one appellate judge for that of one trial court judge. Tonight, you will see an oral argument. Oral argument is an opportunity for the lawyers to emphasize certain legal principles and for the Supreme Court to ask the lawyers questions about the case to help clarify the parties' legal arguments. Don't be surprised if the justices interrupt the lawyer's argument to ask questions. Time is limited, and the justices may want to focus the argument on particular issues in the case. Before the court begins, I want to mention some rules of decorum. During the proceeding, please be quiet and respectful of others. Please turn off all electronic devices, including cell phones. If you must leave the courtroom, please do so quietly. You can find more information on the Iowa Supreme Court and the appeals process and a summary of tonight's case in your program. Thank you, and please enjoy this unique opportunity to see your Iowa Supreme Court in session.
We thank Drew Gensch for that valuable information. Right now, I want to share a cell phone conversation I had with Jefferson County Sheriff Bart Richmond tonight around 9 p.m., where he shares his thoughts after attending the Iowa Supreme Court oral argument in person in Des Moines, Iowa. And as they say in the biz, without further ado, let's go to that telephone conversation. Okay, with me right now, I have Jefferson County Sheriff Bart Richmond on the phone. And Bart, I watched the whole proceedings tonight at the Iowa Supreme Court, and I wanted to get a sense from you, your thoughts of how things went.
Yes, John, I believe it was on live YouTube tonight. I was present in the courtroom for the complete hearing with plenty of support around me. As far as the case itself, I thought there was some very good questions by the justices asked of Elizabeth Estey, which she had a very difficult time answering or clarifying. I thought Charles Gribble did a very, very great job explaining my side of things. So I thought it went very well. I'm sure it'll be in my favor.
Well, I agree with what I have seen and what people will see in this podcast as I share and edit things together as far as showing different segments of the case, and I will encourage them as they watched that they can go to the Iowa Supreme Court YouTube channel and watch the whole thing themselves. But I agree. I mean, right out of the gate, the justices were very interested in what Miss Estey had to say and asked questions right away. And when she would say something to respond to the questions, they had immediate follow-up questions. And I'm going to be sharing those tonight on this episode. So it is definitely a great civics lesson, and I hope people watch this podcast, but I also hope they actually go to the Iowa Supreme Court YouTube channel and actually watch watch the whole thing.
I agree, John. I was very disappointed in Chauncey Moulding. He created this whole thing by false accusations, and then he didn't have the balls to stand up in front of the Supreme Court. I was very disappointed in him pushing Elizabeth Estey to handle this tonight. He misled the public. He misled district court. He misled everybody. He lied about me, and then he didn't have the balls to stand up in Supreme Court.
And just think, there are Jefferson County citizens that voted for him. What are they thinking tonight?
Good question. His credibility's in the toilet. And why he took it this far and then didn't stand up in front of the Supreme Court.
And what's interesting is, similar things have been gone on in Henry County, and County Attorney Darren Stater resigned. His last day was Sunday, February 8th, but Stater had put Deputy Carlos Lopez on the Brady Giglio list. They went to court on it. Deputy Lopez won, and the judge, Rydell, ordered to have Stater removed Lopez from the list, and Stater at least did follow through and do that. But in the meantime, he's now resigned as county attorney. It makes me wonder what the future of the Jefferson County Attorney is.
Good question. In that case with Henry County, Darren Stater did remove Deputy Carlos Lopez from the list.
Correct.
After the decision in district court.
Right.
I went to court last January, over a year ago, and it was ordered for him to remove me from such list. I have yet to be removed from the list.
Wow. And that doesn't gel with me. It does not make sense. And I think that Charles Gribble explained things a lot, and the justices asked him very good questions too. And he explained, how can the sheriff go to the person who put him on the list to discuss the fact that he's on the list?
I agree. And I don't know.
Well, it was nice. The Chief Justice Susan Christensen explained at the end, what the process, what procedures they go through to make a determination on something like on this case. And it sounds like, they're only in session until June 30th of 2026, but she made it pretty clear that within 2 months, so here we are, February 11th, so probably by sometime in April, we're going to get some kind of result, some kind of final judgment on this.
I hope so. I hope it's actually sooner than that.
Well, I'm just
within a month.
I'm just a friendly neighborhood, lovable, fuzzy little podcast host. But looking at it, from what I've seen tonight, it ought to be pretty easy to decide.
I agree. That's the feeling I left there after the hearing. I was live a couple of rows back from the attorneys and listened to the entire thing. So
yeah. Well, I appreciate you calling in, Sheriff Bart Richmond, and once again, you're contributing to podcast excellence. And I know this is going to get resolved. I just feel that sense and right is going to prevail in this situation. And I look forward to talking to you and having you on the podcast to talk about all the good, positive things that are going on in the Jefferson County Sheriff's Department in the future.
That would be great.
All right. Well, is there anything else you want to share with the Southeast Iowa Today audience this evening?
Not at this time. I'm traveling home. I'll be back in Jefferson County probably in an hour or so.
Very good. Well, you be safe out there, and we'll talk to you soon.
Okay. Thank you, John.
Thank you. Bye-bye.
Bye.
Now, before we get back to the courtroom, I want to take a quick obscene profit center break, and then I'll be right back. Hey, give this episode a like and make sure to follow and subscribe. It's free. Pfeiffer Sawmill, your local home for kiln-dried lumber and affordable trailer decking to your specifications, all in Rome, Iowa, serving Mount Pleasant and all surrounding areas. Do you like to throw a hatchet? They've got your board. Call Ben today at 319-931-4544. Did you know that I'm not only one of your favorite podcasters, or even your favorite podcaster, but that I'm an author too? That's right. I'm the author of this book right here, Christy's Journey, The Beat Goes On. This is a true story about my daughter and my family. Back in June of 2019, my daughter Christy, at 29 years old, experienced cardiac arrest while at work at her job in Northeast Texas. The Lord lined up angels to save her, from her fellow employees to first responders to the doctors that figured out what was wrong. It was quite a journey. It turns out that Christy was born with a birth defect in her heart, something her mother and I never knew. Her pulmonary artery was on the wrong side of her heart. Christy was saved, and our entire family is eternally grateful and thankful. I would tell our story to different people, and I would say, the Lord has a plan for us, but I'm not smart enough to know what that is. So many times people would respond to me that I should write a book. Well, I'll tell you, it was the best thing that I could have done, and I hope you are interested in checking it out. If so, it's in lots of libraries in Iowa and in Texas. If you would like to have your own copy of our inspirational experience, you can get it online wherever books are sold, or go to BoBainDesigns.com and get it for $13.57, which is over $3 off the retail price. I thank Jefferson County, Iowa Sheriff Bart Richmond for calling in tonight to share his perspective. Now, I will get back to what happened in Des Moines via video from the Iowa Supreme Court YouTube channel live stream. And the 7 Iowa Supreme Court justices entered the chamber, and Chief Justice Susan Christensen started the proceedings.
Be seated. Welcome to Night Court. We do appreciate everyone showing up tonight. This is a real case. It's just not the real time we normally hold court. Thank you to the attorneys who said yes, whether you felt like you had a choice or not, to coming to Night Court. So we have one case that we are going to hear tonight that will be submitted. It is the case of Richmond versus Jefferson County Attorney, and I can tell by looking at the tables that counsel are ready to argue. So we will start with, let me see here, Ms. Estey?
May it please the court, counsel. The legislature's desire to provide procedural recourse for a witness credibility determination should not be at the expense of a criminal defendant's due process rights or the prosecutor's duty to uphold them. My name is Elizabeth Estey. I'm here on behalf of the Jefferson County Attorney. Under the law today, a criminal prosecutor cannot fulfill his duty to disclose exculpatory evidence without creating a Brady-Giglio list, thereby allowing private individuals to curtail executive power by giving the judiciary the ability to review and reverse a prosecutor's witness credibility determination. A determination that has no impact on the officers, but does have an impact on a criminal defendant's due process rights.
On the officer?
Your Honor, there is no protected property interest because under Iowa Code 80F.1 sub 23, an officer shall not be discharged or disciplined or threatened to be discharged or disciplined solely due to a prosecuting attorney making the determination that there's a witness credibility issue.
It's not been an adverse effect. I mean, you may not be able to be officially fired, but are you ignoring the reality of being on that list?
Your Honor, I don't think that there is also a protected liberty interest here. There's no stigma that's attached to a prosecutor making a disclosure of an exculpatory evidence to a criminal defendant.
Officers would disagree if they are put on a list that says they're not trustworthy, they're not to be believed. Wouldn't that be fatal to their career in law enforcement?
Speculative at best, and I didn't see in the appellee's argument a very clear consideration of that. He does cite to specific case law in Pennsylvania, first of all, not controlling jurisdiction and easily distinguishable on the jurisdiction itself. Pennsylvania's Constitution recognizes reputation as a fundamental right that's subject to a due process protection. Additionally, under Iowa Code 80F.24, an officer does have the ability to seek a reconsideration from the prosecutor, and that's where that determination should remain, not with the judiciary.
Asking the person who made the decision to be the person who decides that the decision was correct. What about due process beyond that? How does that work without this statute?
Without the statute, Your Honor?
You're saying that their opportunity to have it reconsidered is by the same entity that made the decision to begin with, correct? And you think it should stop there?
I do believe that it should stop there. The reconsideration allows an officer to present additional evidence that maybe the prosecuting attorney doesn't have. And right now, a prosecuting attorney has the ability to determine whether or not that officer engaged in any acts of untruthfulness or candor, or as Iowa Code specifies, some other type of issue which places an officer's credibility into question.
Non-existence of the list affect the prosecuting attorney's duty to disclose?
Well, under the law, it's a very broad definition of what constitutes a Brady-Giglio list. It basically just says names and details of officers who have sustained incidents of untruthfulness, criminal convictions, or candor issues, or any other, and then there's a catch-all. So under the code right now, a prosecutor can't share information without essentially creating a list. Obviously, we're coming from a smaller county. We only have 3 attorneys in our office. We can share information verbally with each other, but if you're coming from Polk County or a larger county where you have multiple prosecutors, how are you supposed to share that information with the prosecutor? Any assistant prosecutors or assistant attorney generals who are working across multiple counties.
When a case comes up, explain it. Why do you have to have a separate list?
The legislature created the list, and it doesn't specify whether it's written or verbal. I know maybe I'm parsing too closely, but the fact of the matter is, what if a prosecutor leaves office and then there's another county attorney elected into that office? How is that county attorney supposed to know that there are potentially witness credibility issues with specific officers?
It seems like your challenge is categorical to the statute and saying it's unconstitutional in all situations, but it seems like to me that it would be better to attack it on an as-applied basis if there was some particular instance in which it might infringe on rights, but it seems like you're avoiding that.
Your Honor, I think that the main issue here is not only the prosecutor's duty to uphold the criminal defendants' due process rights, but also the separation of powers issue. The fact that a prosecutor has a core function as a member of the executive branch in making some of these witness credibility determinations, determinations about charging decisions, decisions that are generally not subject to judicial review.
Could we go back to your point about the legislature is kind of the one that created the list in the first place? It's odd that the legislature wouldn't be able to create procedures like judicial review if indeed it is the legislature that created this list in your mind.
Yes, the legislature did create the list. It impedes our ability to disclose the exculpatory information because we have to have it on a list based on the way that the legislature has defined it.
With the premise of that argument, that isn't it true that a prosecutor can disclose impeachment evidence whether the officer is on the list or not in the criminal case? In fact, the Sixth Amendment and the Supremacy Clause would require Brady disclosures.
That is required. Again, I don't know how a prosecutor would be able to collect the information necessary without creating a list. And of course, under the shared knowledge doctrine, the assistant county attorneys would also have to have that information.
Disclosure have been in this case in a particular, just to kind of make this more concrete. If the sheriff were, his credibility were at issue and he were called as a witness, whether he's on the list or not, what would the Brady Giglio disclosure have said?
Telling the criminal defendant's attorney what the issues here were and why the prosecutor believed that there was a lack of candor.
Or the reason for the lack of candor?
I would state that there were some emails requesting additional information about an investigation into an excessive use of force, and then
I think you're trying to make that be about candor. Can I get you to agree that according to the statute 80F.1 sub 1, that the list includes details of officers who have sustained incidents of untruthfulness? We don't have that here, do we? Criminal convictions, we don't have that here, do we? Candor issues, is that where you're hanging your hat? Okay, and maybe being a bit of a jerk about emailing back and forth, is that really candor? I mean, help me understand, how does that, because it doesn't say, or being a jerk, it says candor issues. How is that candor?
the statute says, or some other type of issue which places the officer's credibility into question.
Make a person's credibility. I mean, I've met a lot of jerks in my life. That doesn't mean I question their credibility. They are honestly being a jerk. But how does that necessarily equate to that?
Your Honor, I don't really want to go too much into the facts of the case, but I think that there is...
Trying to figure out. We know, we've read everything.
Well, I think that here at issue was not just the fact that there were emails that were not answered. Our office...
I want to know the facts because this is exactly what's at issue. What did he do that classifies as being put on that list? And just say for the sake of argument, I know you have not conceded on this, but for the sake of argument, let's say that we do think that that has more meaning than you're saying just being put on a list. There's more to it. It's got a lot of negative fallout by being on that list. I think they call it the do not call list. So help me understand the facts.
Well, Your Honor, essentially there was a concern about an excessive use of force, and that happened in April of 2024. On May 1st, the county attorney was made aware of the incident by reviewing some body camera footage that was provided to us from the Fairfield Police Department. On that date, the county attorney emailed the sheriff saying, "Are there any concerns here? Have you reviewed the footage?" There was no response. 6 days later, the county attorney also sent another email stating, if you don't respond to this email, I'm going to assume that there's no problem and there's no violation of policy. Again, there was no response, and these are exhibits that are,
County attorney give him an out to give no response. He said, if you do not get back to me, blah, blah, blah. Okay, I'm not going to get back to you. Wasn't that an option?
it was. And at the time of trial, the sheriff stated that he kind of agreed with that statement, which is why he didn't respond. Yes.
I have a concern. You're not appealing the merits, right? So you want us to rule that it was unconstitutional for Judge Farrell to say that the sheriff doesn't belong on the list, but you're not arguing he doesn't belong on the list.
Your Honor, that the statute is written.
The list, that's it. You're not challenging the merits, yeah.
Farrell erred when he did not grant our motion to dismiss on the constitutional grounds.
What is the power at issue here? What is it exactly?
The power, as the prosecutor has a duty to the executive as the law enforcement officer in the state to make his own determinations when it comes to witness credibility.
Right? In a particular case, he can still do that, right?
But again, if there are sustained incidents of misconduct, how would he be able to collect that information and retain it? He can't even create a list on his own computer.
Is the power that we're talking about collect?
Without being able to collect it, and without, he would not be able to retain it in order to disclose it. And by collecting it, he's created a list. And by creating a list, then the judiciary has the ability to review that list and reverse those determinations.
Have we held that in any case?
Pardon?
Said that creating a list on a spreadsheet on your computer, that is the kind of list we're talking about here?
Case of first impression, you have not had the opportunity to review this statute yet. And so again, that would also speak to our vagueness argument, the fact that perhaps we don't know what the legislature intended enough to put us on notice to know what actions are inappropriate.
Understanding the argument about the judicial officer involvement in the credibility determination, it seems like it proves too much, to me at least, because the entire Brady regime is predicated on judges making determinations about materiality and credibility of witnesses and materiality of evidence, which is how you assess a Brady violation. I mean, so this whole construct is premised on judges being involved in that determination. So how does this list violate or contravene that?
The judiciary does have the power to review the statutes and ensure that the actions of the prosecutor uphold his constitutional duties and don't violate the Constitution. What we're arguing here is give us the opportunity to fulfill our constitutional duties. We're asking for more transparency, not less. And I would argue that some of those reviews by the judiciary are about whether or not a criminal defendant's due process rights were violated, not whether or not we provided too much information to a criminal defense attorney.
But nothing prevents the prosecutor from presenting the information. I mean, it seems like your fallback position here is that you just can't physically type a list somewhere. I mean, the prosecutor, you said it's a 3-person office. It doesn't seem like this is a real complicated issue. If the prosecutor believes that this particular officer needs to be disclosed in a case, why can't that be done? The Judge Farrell's order doesn't say that can't be done, and the statute doesn't say that.
You're right, Your Honor. And if we are able to just retain all of the information about the officers and the specific, excuse me, I see that my time is done.
Sure.
If we are able to retain all of the information and disseminate it verbally, I suppose, without violating the statute, which also doesn't specify whether it's a written or a verbal list, then I suppose under that hypothetical, I would tomorrow be able to disclose that information to a criminal defense attorney, but I don't know that I would be next week. And this is a duty that the prosecutor has. It's not a delegable duty. And again, going back to the shared knowledge doctrine, I don't understand how we'd be able to share that information with an attorney general who may come in and start prosecuting the case on our behalf. Thank you.
Chief Justice Christensen, Justices McDermott, McDonald, Waterman, Mansfield, Oxley, and May. May it please the court. This is an appeal that arises from the Jefferson County District Court, and it arose when the county attorney placed the Sheriff Bart Richmond, on the Brady-Giglio list. At the same time he did that, he sent a letter to the sheriff saying, you can no longer be a witness in this case, the matter that we have at present, or any other case in the future. You are not a credible person, you are not a trustworthy person, and on the same date, he sent the same letter to most law enforcement agencies in the State Patrol, the DCI, the attorneys for the Southern District, and other municipalities in the state. So I think that brings us to why this particular issue is particularly important to police officers in the state because of their reputational interests in not being placed on that Brady-Giglio list. Quite frankly, if you can't be a witness and you can't engage in any law enforcement activity that would result in you being a witness, how can you investigate crime? How can you arrest individuals knowing that that's going to make you a witness? And the county attorney has already said that you can't, and he's already disclosed that same information to every law enforcement agency in the state.
Would the county attorney have the option to say, sort of to themselves, like, this is an officer that I don't really find trustworthy, and I'm just not going to prosecute cases if they've been involved in them?
And basically, looking at the cases, at least all that I've reviewed, including what Judge Farrell said, is that whether or not someone's on the Brady-Giglio list or a do not call list or a Lori list, however any state would define it, does not in any way alter or change the county attorney's obligation to disclose all exculpatory information bearing on guilt or innocence. That would include the name of the officer, the incident, the body cam, the video, the statements, whatever else, the reports that the officer has made. There would be no difference there. But placement on the Brady-Giglio list does certainly have a big impact on the officer. If, in fact, the officer has been told that he is no longer credible or trustworthy in this case or any in the future, that means that that officer is of very limited value to his own department, to the citizens, to even the county attorney, because he's been found to be not credible, not in this particular case. In other words, it extends beyond any allegation that there was any wrongdoing in this particular case, but to all other cases heard anywhere in the state of Iowa.
Counsel's argument that the list itself and the judicial interference in the list, I guess, interferes with their ability to discharge those duties, that they can't maintain the information, and maybe in a bigger office this would become problematic, and it is in some way interfering with that executive function.
See how it would interfere with the executive function, and if I'm not sure I understand completely your question, but obviously
their argument, as I understand it, is maintaining the list itself is critically important to discharging the duty to disclose exculpatory information, and this statute interferes with that ability.
Say, no, Your Honor, it does not. In fact, the duties of the county attorney are the same whether someone's on the list or not, and our argument would be that no one should be placed on that Brady-Giglio list until there was an opportunity to work on their reputational rights. In other words, their right to determine whether or not they should be placed on that list.
A question that has to do kind of with the facts. I believe opposing counsel agreed that one portion of the statute on 80F.1 sub 1 is candor. That's where they're hanging their hat. Can you give me an example with this set of facts, if it had gone just a little bit further, what is your definition of candor?
Court looked at that, and they looked at it in terms of not only police officer cases, but in terms of attorney cases and what this court has said. And basically what the court has said, what Judge Farrell said, what this court has said in disciplinary cases, is candor is really undefined, but usually for untruthfulness and candor, there must be some showing of intent to deceive. In other words, it can't be something that occurred and was no intent to misinform someone or to lie, but it must be something where there is intent that is shown. And certainly that is not the case here. The back and forth between the county attorney and the sheriff were with respect to an investigation of an officer who was employed by Jefferson County who was assisting the Fairfield police. And the back and forth there resulted in an exchange and finally an agreement that, okay, if you're not responding, that means that you're not in any way adversely criticizing this officer's conduct or that you're going to penalize them in any way through a suspension.
Of where the communications, and it sounds kind of trivial when you just talk about emailing back and forth, and I think I used the word somebody being a jerk, whatever. But underlying, it's pretty easy to see why the county attorney was knocking on the sheriff's door, that video. So does that have anything to do with the level of candor or the degree of candor that was discussed here?
Been pursued further, perhaps, but it was not. The county attorney pretty much dropped it on the second request when both parties agreed that, all right, there was no need to respond any further. That was how this one came out. The Judge Farrell certainly did say that the sheriff certainly could have cooperated more in this particular case, but he didn't find that anything raised to the level of untruthfulness or lack of candor. And as you said, ADF-1 talks about sustained incidents of untruthfulness or lack of candor, meaning multiple, while use of the word incidents meaning plural, and sustained meaning there must be some findings, either admissions by the officer or through the use of progressive discipline, some findings that this particular individual has been disciplined in the past for the same incident before a Brady Giglio should even come into play in this particular case. The way the statute seems is now, if you were to find this unconstitutional, it would not interfere with the executive, it would interfere with the right of the officer to in any way protect their reputational rights, because it would make the county attorney not only the prosecutor in the case, determining who's on the list, why they're on the list, but even if there's a request for reconsideration, it would be back to the county attorney to review his own reasons.
The fact that reading this statute with all the amendments and the way it is now, so ADF.1 sub 24 sub G sort of has this carve out, this sort of, nothing in this subsection kind of trumps the Constitution. So it recognizes the Brady obligation. But then that says subsection, which means subsection 24. And we're talking about 25, so there isn't sort of this constitutional carve-out in 25. What do you make of that?
I really think that the 25 is simply to make sure that the due process rights of the police officer are protected, and there's a way for the police officer to make sure his reputational rights.
That the county attorney is making is that 25 is unconstitutional because it's an effort for in essence, to trump the county attorney's obligation to recognize the constitutional obligation under Brady Giglio. And
obligation under Brady Giglio is to produce all exculpatory information, regardless of whether someone's on the list or not. So I don't see that there's any issue there.
Carve out only this constitutional carve out only applies to 24 and not 25 makes any difference.
I see that the obligation there is the same. There was some argument early about whether or not that if you were placed on the list, you could come back and argue again that you should not be. But if you're placed on the list for a particular reason, in other words, undue use of force, there's video to support that, It seems that going back to the same person that put you on the list in the first place does not really help or with the officer's certainly reputational rights.
Just clarify a factual piece for me. Are we talking, council discussed sort of a list, even internal list, a spreadsheet on somebody's computer inside their office? Is that a qualifying in your mind as the Brady-Giglio list?
List regarding officers who the county attorney feels have misbehaved in some way in the past, used undue use of force, any of those things. If the person is not on the Brady-Giglio list, I'm not sure there's anything that precludes the county attorney from maintaining such a list. But it's the placement on the Brady-Giglio list, the distribution to everyone in the state, the fact that you can't be a witness in any case.
Follow up on Justice May's Justice May's question. So a county attorney can have an internal file system or something typed on their computer where they're keeping track of particular officers, but that's not considered a Brady-Giglio list itself. Is that what you're saying?
A Brady-Giglio list unless it's handled in that manner. There are cases where county attorneys have created that list and then said the fact that they're on that list means they're on the Brady-Giglio list. That would certainly run afoul of the statute if in fact they did that. If they made their own internal list about where they've had problems with officers, I don't see that there's anything that would preclude them from doing that.
Be a kind of a runaround around the statute? Isn't the purpose of the statute to give the officer an ability to challenge his consideration?
That would be if the officer could even discover that list. In other words, if it's not identified as a Brady-Giglio list, under the law, under ADF, the county attorney is supposed to give the officer notice that they're on that list, a chance to get documents, a chance to ask for reconsideration, to do all those things. If they're keeping a secret list, which is really a Brady-Giglio list, yes, then that would run afoul of the statute.
I have my own history of being in a prosecutor's office, two people, not as big as this one at issue, of three, working relationship with law enforcement. And I think people are crazy if they don't think we have in our heads, we know who we can trust. We know who has pushed the buttons with us. We never created a list at that time. This was many years ago. But is that something, the comments that I have in my head, are you saying that those need to be resorted to a piece of paper, that so-and-so cannot be trusted? I've had problems with him in the past.
Saying that if those need to be put down on a piece of paper?
About lists created in their heads.
Be put down on a piece of paper. I think the question was, what if they are put down on a piece of paper?
That if that's a way of getting around it, because I'm just wondering, how is that done? I mean, everybody has experiences, especially the longer you're in a job and the more you know someone.
And we assume that that is done by everyone, but that's quite different than under ADF putting someone on the list. If you're going to put them on the list, then you have to give the officer notice that they're on that list and give them an opportunity to obtain documents, reconsideration, and under the laws that stands now, the right to appeal with respect to their reputational interests.
In this case, is the county attorney should have just kept it in his head, called his friends and buddies, and told everybody else you can't trust him as far as you can throw him?
Did that, then we'd have questions. Probably, I'm not going to find out about that, am I? There's no way, or defense counsel, I should say, is going to find out that that's being done. If that is being done, that's one thing. But if you put someone on the Brady-Giglio list, certainly as defense counsel, that'd be the first question you'd ask, is this officer on the Brady-Giglio list? If they're on the Brady-Giglio list, that's immediately going to call into question their truthfulness, their reputation for honesty, so on and so forth. So some of these informal things, no, I believe there's no way to control that distribution, but we're talking about officers who are placed on the Brady-Giglio list and how they appeal from it. And the way it stands now, without 81...
Presented to the defense attorney in a particular case, and how's that presented at trial if the officer were in fact called, so then it could be used for cross-examination?
Basically, it's not. I mean, what's presented to the opposing counsel would be everything to do with the case at issue, which include when the incident took place, the body cam, the videos, all those things. Most of the time, information contained in a confidential employee file is confidential. Well, this court has said in State versus Garrison that you can, if you find that to be particularly relevant, some of the information in a personnel file can be disclosed, but ordinarily it's considered confidential. So to answer your question, it would be the same. Everything the county attorney has to turn over exculpatory evidence, all of it, whether it bears, how it bears on guilt or innocence of doing that. But with respect to the officer, making personal comments about the officer, now you get into a very gray area. Are you really saying he's on the Brady Giglio list, but we're not going to disclose it?
Question, is that the purpose? So if there is a Brady Giglio list and someone's on it and they haven't challenged it, and then they are going to be called as a witness in a later case, is the information just, yes, this officer is on a Brady Giglio list, or is there information provided about why and how is that used?
Be provided that the person is on the Brady Giglio list, assuming that there's been no challenge to the placement on that list, and he hasn't taken advantage of any of the provisions of ADF as far as getting a person off that list who's been on it maybe years ago.
Wait, could you address, isn't this rational basis review our most deferential to a legislative enactment?
It would be rational basis review. It would not in any way be like Varnum, where there's a suspect classification or an intermediate scope of review. This would be rational basis where the burden would be on the state to show, in fact, that this is purely and completely unconstitutional under any rationale that could be advanced for it.
If you don't mind, before you leave, quick, in your brief, you talked about, hold on here, let me see if I can find it for sure. Yes, in your brief, one of your issues was that the code section is abundantly clear through legislative intent and language.
Your Honor?
What you talked about in your brief, you said it as one of your issues, but I didn't feel like it was really fleshed out much. What is, you talked about legislative intent as supporting your interpretation of this statute. Can you expound on that?
I said that, what I really meant is that the statute itself, I think ADF 125, the fact that your authority comes not only from your appellate review, but from the grant of authority being granted to you by the legislature by the passage of ADF 125, means that you have the power to review it, and it doesn't detract from the executive power because the obligations of the county attorney are the same whether someone's on the list or not on the list. Thank you.
Just to touch on a few of the points that you just asked Mr. Gribble. Regarding the candor issue, Judge Christensen, the prosecutors have a duty to learn about exculpatory information as well from every member of the prosecutorial team. That includes law enforcement. We still don't have all of the sheriff's operating procedures, even though we requested them. And we brought this conduct to the sheriff's attention. So when we talk about candor issues, especially when it comes to a supervising officer, it's very important for us to know that we can get a full, or we can have a full, frank conversation with them.
I mean, we have a situation in our state, which I think it's a good system, where both the county attorney and the sheriff are elected by the citizens of Iowa, and they have to kind of work with each other, even though one isn't answerable to the other. And really, I don't think the Brady Giglio list is intended to be the tool to force that cooperation, is it?
Right, Your Honor. I just wanted to speak to the candor issue and address the Justice's concerns regarding the candor in this specific issue. I agree with you, though. Obviously, this situation has not made the communication between our offices any better.
Ask you about in your brief, you said as to a Fourth Circuit case of Savage, which talks about absolute immunity, but you didn't. I don't think that you addressed our case of Beck versus Phillips, which talked about when you're looking at future, whether or not an officer would be a credible witness in future cases, that there's some administrative levels to that, and so that might not be absolute. Could you address our Beck case, please?
First of all, I believe that this case was written, this opinion came up before this law. But yeah, specifically in Beck v. Phillips, the court found that writing letters to the police and the mayor were not protected by absolute prosecutorial immunity because they were more administrative and they were not intimately associated with the judicial phase of the criminal process. Your Honor, and
Different than deciding to put someone on a Brady-Giglio list, which is really, isn't it more forward-looking at future cases? It's not limited just to the current criminal case that's at hand, right?
I would argue, Your Honor, that it depends on, I think that the issue here was to whom the information was disseminated and how it was disseminated. And I think that if I'm speaking specifically about if you're disclosing information to a criminal defense attorney. Did that answer your question?
So the Brady-Giglio list is not to be disseminated beyond a criminal defense attorney. So when opposing counsel was discussing the fact that a sheriff was put on the list and was disseminated across the state, is that not a proper use of a Brady-Giglio list?
It depends on whether or not we're talking about the prosecutor being completely immune from any harm that his conduct would cause. I think that the immunity focuses on the conduct itself, which is what I'm arguing here. The conduct itself being able to make those witness credibility determinations and harm that may flow from that conduct, especially if they're more administrative actions, would not be protected by that absolute prosecutorial immunity.
To disseminating the fact that this person is on a Brady-Giglio list beyond a criminal defense attorney, are you saying that that would be administrative?
I believe it would depend on the facts, Your Honor. I'm certainly not trying to dodge the question, but I think, as I stated earlier, sometimes our attorney generals would come in and take over a case for us. I think at that point we would also disseminate the information to them.
The way opposing counsel described, at least in this case, this particular Brady-Giglio information was used.
So our policy specifies that we will be sharing that Brady-Giglio list to supervising officers. In this case, since it was a sheriff, our county attorney decided to share that information with law enforcement throughout the state who may be working with the office.
Let me go back to the question of candor, counsel. The statute specifies candor issues. Is it your position essentially that anything that the county attorney asks of the sheriff has to be disclosed, or else that can create a candor issue if they don't respond to your request for information?
Out of time, may I address Justice May's question? No, I'm not stating that. I believe that in this situation with these facts, that it rose to the level of a candor issue. Again, when we were investigating the potential for an excessive use of force, and I will also note that we didn't just drop the issue. We had to outsource it to Keokuk County Attorney's Office to investigate as well. So I think given these facts, and again, it's the prosecutor who makes those determinations regarding witness credibility. And on these facts, it was determined that this was a lack of candor, and that necessitated his placement on the list. Thank you.
Okay, thank you. The case of Richmond versus Jefferson County Attorney is submitted. My colleagues are going to get mad at me for doing this, but this is night court. And when we go on the road, court on the road, we usually have just a little bit of conversation at the end. The official hearing is over. We can't talk about what we just heard or what our thoughts are or our impressions. I just want to let you know the next thing we usually do, if it were daytime, we definitely would do this. We would adjourn, go down our door. We have a rack to hold our robes. Might go grab a cup of coffee, take a quick break, and then we get back into our conference room. And we sit like cows in a barn, always the same seat. And we'll start the conversation. The world doesn't know it. We know that one person has been assigned this case, but all of us are going to be involved in the case. And it might end up being that the person assigned is not the person that ends up writing the case. Who knows? But what we'll do is the person who is assigned will start talking about the case. Okay, this is what happened at the trial court level, blah, blah, blah. The appellant argued this, the appellee argued that. My impression is, if I was the only show in town, this is what I would do. I would affirm or I would deny, and here's my reasons. And then a justice right next to that person is next to go. And that person might say, I think I 100% disagree with everything you just said. Or they might say, I'm with you. Or they might say, I'll see what you're right. And the conversation goes back and forth until we get all around the table, one at a time. And then the person who it ends with, which is the author, for a supposed author, takes all of that into consideration. And then when we part for the day, we go to our own respective chambers and have our law clerks help us, and we scratch our heads and we put together something, and we start circulating our draft. And then people start chipping away at it. They like it, they don't like it, they want to write separate, whatever it may be. So it might be a few weeks, maybe a couple months until we're done, but please don't think for a moment that we're not working on it. We might disagree, and we have to go back and forth for a long time. So that's usually one of the most popular questions that gets asked of us. Where do you go from here? And it's not much more glam than that. That's what we do. That's how we make the sausage. And we have some cases also with no oral argument, and we make the decision whether or not to have oral argument. And those cases are usually ones that we feel like the briefs are what we need. We don't have to flesh out a lot of the facts. We have a pretty good grasp of what the issue is, so we might not require oral argument. But we handle it other than that the same way. We conference it in the conference room, we take turns, and then when we're done and there's no more ink to spill, then that's when we start cleaning it up and making it look pretty for you guys. And so that's the process. I will open it up for questions if anybody wants to ask a question. We don't get to do this during the day because we have several cases. This is our only one for the night, and I am more than happy to entertain questions. And we've never, ever had a situation where someone didn't ask a question. So do not let this be the first time.
If you want to hear and see the questions from the attendees, you'll have to watch the Iowa Supreme Court's YouTube channel. I would have included them, but it was hard to hear the folks that were asking the questions because there were no microphones near them. But I want to share dictionary.com's definition of the word candor. It was used quite a bit tonight, and I thought it important to share the meaning of the word with you, loyal audience. Candor, C-A-N-D-O-R, the state or quality of being frank, open, and sincere in speech or expression. Freedom from bias, obsolete kindliness, obsolete purity. Thank you for watching, and as always, I want to thank my sponsors, Griner Auto Body, Car Doctor, McDonald Boneyard, Your Choice Family Restaurant, Girling Repair, B&B Propane, and the family of Jet Stops, CW Tree Trimming, LLC, and Iowa Technology Systems. Do me a favor, put your comments down below because I want to know what you're thinking, and so do all the folks that watch this. And I got just one more thing to say, and you know what it is. Stay friendly, Southeast Iowa. I could hear you saying that with me.